Welcome everyone. Thank you for joining us. We're on time. We always like to be punctual. Thank you guys for everyone for joining me today. I am Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I am here for your live employment law Q&A session. You are here to learn about employment law, and I'm here to tell you about employment law. Again, I'm Lior Samfiru, one of the founding partners of Samfiru Tumarkin LLP. We practice employment law across Ontario, across Alberta, and across British Columbia. And I take questions every day by email, by phone, and I also take them right here on this live stream. If you're watching me right now on Facebook, on YouTube, on LinkedIn, you have the opportunity to ask a question about your legal rights. You have a question to make sure that your question is answered. I'm here waiting for your question. I'm happy that you're here watching. That's fantastic. That's the best thing. But also, I want you to ask questions because number one, it makes things more interesting to me, and it's really all about me, right? But beyond that, it helps you solve your workplace problems. And by asking me questions about your legal rights, you'll also be able to help others that are watching. Maybe you have a question because you lost your job and you want to understand what this all means. You maybe have a question because your boss is mistreating you. Maybe it's a bullying, harassment situation. Maybe you're having a medical issue and your employer is not being particularly helpful or accommodating. What does it mean? What do you do? How do you respond? Ask, I will tell you. And of course, there's many other topics beyond the 30 minutes of this session. Easy to connect with me as well. If you want to connect with me, all you do is you go to employmentlawyer.ca. Again, employmentlawyer.ca. You see that address right here on the screen. And when you go to employmentlawyer.ca, you'll find the email address there. The phone number is there. Everything you need to connect with me is there. Of course, you can also read about employment law. If you prefer not to contact me, you want my office to contact you, you just fill out a form. We'll do that. You get it. It's easy to connect with me so that we can help you enforce your employment law rights. But that's after. Right now, you're live. I'm live here with you for you. Again, I'm Lior Samfiru, the employment lawyer. I'm going to start answering questions, but you have so much time right now to type it in. Make sure you get the question the way you want it. You hit enter. Magically, it's going to pop up on my screen right here. I'll read it and I will answer it. So don't wonder whether you should ask. I'm telling you, ask. Okay, ask the question. Give me that opportunity to help you. And I hope that you'll feel better once you've done that. But, I've told you what I'm here to do. Why don't I just go ahead and do it, right? Let's start answering some questions. Thank you again for joining me. Ask your question. All right, our first question of the day. Thank you. Mike has our first question. Mike says, I was moved to another department against my will. This reduced my commission more than 30%. I made a complaint to the company hotline, and in 1 week, they fired me. Wow. Is this reprisal? Well, here's the thing. It's not necessarily a reprisal. Reprisal happens in a situation where you're enforcing overtime, vacation pay, you're complaining about human rights violation or bullying, harassment, and you get fired because of that. We call that a reprisal. It's illegal. You cannot be punished for enforcing your rights. Now, what I want you to understand is that change, the change that the company implemented to move you to the department to pay you less, was not something that they were allowed to do. Okay, what I mean by that is that type of change results in what we call a constructive dismissal. Because your terms of employment have been changed in a significant way, you could have considered that change as a termination, as a constructive dismissal, and require the company to pay you severance. Well, in your case, you actually don't have to do that because they just went ahead and let you go. They're allowed to let you go, even though it's unfair, as long as they pay you your full severance. Now, you didn't tell me anything about how much severance they've offered, etc., but I can almost guarantee you that a company that's going to treat you this way are also not going to offer you proper severance. So it's very likely that you've been wrongfully dismissed. So what needs to happen right now, Mike, is you need to call me in the office, okay? We need to connect. I want to find out exactly more about your job, your compensation, your years of service, and then I will tell you what you're owed, and we'll go ahead to get you what you're owed. So, Mike, to get a hold of me, very easy to do. You just go to employmentlawyer.ca. It's right here on the screen, employmentlawyer.ca. You'll see my phone number there. My email address is there. And for everyone else as well, if you lose your job, I don't care if you work for 6 months, for 20 years. I don't care if you're young or old. You have to contact me if you lose your job. I can always guarantee you that whatever that employer is putting on the piece of paper, what they're willing to pay you is not what you're owed. You're owed a lot more. So you got to call me, okay? employmentlawyer.ca. Mike, thank you for that question. Happy to have had the opportunity to speak with you and get some answers to you. Those joining us, again, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. And you see how easy it is. Mike had a question. He asked it. I answered it. You can do the same thing. Don't be bashful. You have time. Ask your question. Make sure you get it right. I'm going to continue answering questions right now. Let's see. Jarvan has questions. Jarvan, I see you have 1, 2, 3, 4, 5 messages here. Let's see. I don't know if I can answer. I really should kind of try to condense it more so I can read it. You have a question regarding policy compensation for additional days work during on-call duties. You work for a tech industry full-time. You expect to perform on-call duties. So, Jarvan, I'm trying to read various messages. Maybe you write me one little paragraph with the question. I will do my very best to answer it, just so that I don't have to try to skip messages and try to read it. So I'm still here, Jarvan, asked your question. All right, continuing. Next question is from Daytona Beach Bad Boy. Love it. Why can't you assist union employees with employment issues? Can you tell us more about what options union employees have? Well, the reason no lawyer can assist the unionized employees is because the law says that the only one that can help a unionized employee is the union. So a unionized employee can't hire a lawyer to deal with their employer. It has to be the union. So it's not a decision that I made. It's not a decision that lawyers make. It's simply the law. So if you have an issue with your employer, normally the answer as to whether or not your employer is right or wrong is in the collective agreement. And the only one that can help you enforce those rights is the union. So your only option, really, if you have a problem with your employer, if the employer did something to you, is to speak to the union and get the union to help you. There's really no other options. So thank you for that. All right, let's see. Next question is from Maddie. Many employees in my department do unpaid overtime on a regular basis. Many of them are paid hourly and they are non-managerial. This department also fires people frequently. How do I deal with this? If somebody complained, they would likely be the next to get fired. Can I complain to the Ministry of Labor? So here's the thing. First of all, there's no such thing as unpaid wage or unpaid labor. So if you work, you have to get paid, even if it's not overtime. So in Ontario, if we're talking in Ontario, I'm not sure exactly where you are, Maddie, but if you're in Ontario, overtime is paid if you work more than 44 hours a week. So anything over 44, you have to get paid time and a half. But if you're paid hourly, you still get paid if you work less than 44. You have to work for all hours paid. If your employer doesn't pay for the time worked, and if they don't pay overtime, it's illegal. They can't do that. They also absolutely cannot fire someone for demanding overtime, for demanding pay. It's a reprisal. Okay. Yes, you can complain to the Ministry of Labor. You should complain. These types of things, because they're so outrageous, they're actually easy to resolve. I can help in that situation, or the Ministry of Labor can help. Now, here's the thing. If someone loses their job, that person cannot get help from the Ministry of Labor. I want to be very clear. This is true in all provinces. The Ministry of Labor, the government, cannot help a person that lost their job get their full entitlements. They can only help enforce a tiny portion of a person's entitlements. To get someone's their full entitlements, they need to speak to me. If they don't like me, they can speak to another lawyer. That's fine. But you cannot go to the government. You can go to the government if you're owed overtime, if you're owed vacation pay, if you're owed minimum wage, etc. You absolutely can, and you should. But you cannot go to the government if you lost your job. So, Maddie, no, what you're describing, completely illegal, not something an employer can ever do. Probably the worst thing an employer can do is not pay someone and then fire them for standing up for themselves. Illegal. Okay, I'm here to help. If you want to connect with me or my team, employmentlawyer.ca. Again, employmentlawyer.ca. Thank you for that question. Very good question. I'm going to continue answering questions. More questions are coming in. Keep them coming. Don't be bashful. Keep the questions coming. I want to answer them. You have time. You have plenty of time still. No rush whatsoever. I'm Lior Samfiru, of course, the employment lawyer with Samfiru, Tumarkin, LLP. I'm here to answer questions. So I'm going to do that right now. I'm going to continue answering. Linda B has a question. Is it legal for an employer to make no allowances for bathroom breaks and force you to use earned leave for them? If I need to use the bathroom outside of a scheduled break, I lose 15 minutes of leave. No, that's not appropriate. Absolutely not. Now, I say not appropriate, but here's what I mean. And then if your employer allows you to earn leave, they're not actually required to do that. So my point is, there's no law that says an employer has to allow you to earn leave. So if they allow you to do that, and then they have you use it when you go to the bathroom, I guess it's okay because they were giving you something, that leave that they weren't required to give you. So if it was different, for example, you didn't have any earned leave, you simply were just told, too bad, you can't do it, well, then that's not legal. Okay, that would be a huge problem. But if your employer is giving you a leave and telling you when to use that leave, that's okay. It's kind of like in a situation where your employer is only required to give you, let's say, 2 weeks vacation. They're giving you 4 weeks of vacation, but they're saying those extra 2 weeks you can only use in June. Well, because they're not required to give you those extra 2 weeks, they can tell you when to use it. So it's kind of one of those things, Linda. Hopefully that makes sense. If I confused you, if it doesn't make sense, or if I misunderstood the question, please ask a follow-up. I'm still here, not going anywhere. And I'm happy to help you. Again, thank you for that question. Lior Samfiru, that's me, the employment lawyer with Samfiru, Tumarkin, LLP. Lots of questions today, guys. Loving it. So I'm going to continue answering questions right now. I want to make sure I get to all of you. I will get to you, okay? We're here till another 20 minutes or so, plenty of time. All the questions are going to be answered, okay? So just bear with me. Moridiri has a question. Hopefully I didn't mispronounce this. I was off on a disability leave for 2 years. It was discontinued when I turned 65. I was cleared to return to work in June 2023 and was referred to the disability department. My employer sent me for a physical examination. I was deemed physically unable to do the job I used to do, and they have not found me a position. What can I do? What are my rights? So I think what you mean is your insurance company cut you off at 65 because usually the insurance policies only cover you till 65. Now, here's the thing. The mistake, I think, here was to agree to go to a physical, because your employer can't require you to go to a physical. All you need is a doctor's note. If your doctor says you can do the job, your employer can't argue with you. They can't demand that you go somewhere else for a physical. They have to do what your doctor says. But in this case, if you saw someone else and they said you can't do the job, your employer has to find a way to accommodate you. So the question now is, could your employer accommodate your limitation, but they're choosing not to? Or is it really a situation where there's just no ability to accommodate? That's the real question. Here's the thing. In most situations, the employer is able to accommodate. It's a very high duty. They have to accommodate you, even if it's difficult, even if it costs them money. They have to find a way. So if this is a situation where they're just not doing it, they don't want to work hard enough to accommodate you, that's potentially a human rights violation. Illegal. Okay, I can help you with that, absolutely. On the other hand, if they tried, they looked, they made all efforts, but there's just no ability to accommodate you, then at that point, you have to stay off on unpaid leave until either they're able to accommodate you or until your limitations change. Okay, hopefully that makes sense. Let me know if it doesn't. And I certainly wish you all the best. Always happy to connect with you as well through employmentlawyer.ca. Thank you for that question. All right, Nick has our next question. I received a termination letter, 30-week salary continuance, 39-week lump sum. After 25 years of service, I was told that if I asked for any changes, that my employer would add mitigating income limitations. So 69 weeks after 25 years of service. Now, I don't know anything, Nick, about what kind of job you're doing. I don't know how old you are, but it's quite likely that you're owed potentially 24 months of severance, 2 years. Okay, so the difference between 69 weeks and 104 weeks, which is what 2 years is significant. We're talking about an 8-month difference. Don't worry about this whole mitigation income nonsense. We can resolve it. So no, you're owed much more. You're likely owed close, if not exactly 24 months. So let's get you that. Okay, let's make sure you get that. You've probably been offered about 15, 16 months of pay. You're owed 24 months. I can resolve it. We can negotiate with the company, get this resolved. Don't worry about it. You have to call me. Okay. This is exactly what 95% of what my firm does. We do this every day. We resolve these things multiple times a day. So Mick, next step, you connect with me and my team. You do that through employmentlawyer.ca. Again, employmentlawyer.ca. And by the way, I mentioned to Mick about severance and how much severance he's owed. Well, let me tell you how Mick or anyone else here can find out how much severance you're owed. And in Mick's case, he was offered 69 weeks, 30 plus 39, that's 69. And I told him that he's owed about 24. Well, how do you find out how much you're owed? Very, very easy. You go to pocketemploymentlawyer.ca, again, pocketemploymentlawyer.ca, and you use our severance calculator tool. It's right there. It's completely free. It's completely anonymous. It's going to take you 20 seconds to use it. You answer a few questions, and it's going to tell you how many months of severance you are owed. What's the total compensation? It can even calculate that in dollars if you wanted to. So it's free. It's anonymous. Pocketemploymentlawyer.ca. Over 2 million people now have used it. Use it as well. The first place you go to if you lost your job, like Mick, or if you're worried about losing your job, or maybe you're just curious. You're wondering, hey, what would severance look like for me? Pocketemploymentlawyer.ca. Use the severance calculator. Okay. Let's see. Where did I leave off here? I think our next question here is from Jennifer G. I'm in a family-run business where siblings are equal shareholders. What say do shareholders have in the operations of the business? Well, it's up to the shareholders to decide amongst themselves what and how the business is going to be operated. The law stays away from that. It's up to the business to decide who is going to be in charge and how they're going to split duties, etc. Let's see. Next question comes from. Let's see. Next question comes from Bimal. Bimal is joining us from YouTube. The company my wife worked for has reduced wages for salespeople more than 10% and changed commission to make the goals impossible to achieve, reduction of 15 to 50%. It's a huge company. What can sales do? So unfortunately, there's really two options only. Option number one is you do nothing, is you accept and you continue working. The second option is they may be able to consider this to be a constructive dismissal. In other words, by changing the compensation, by reducing their compensation, you may have the ability to consider the employment as being terminated and force the company to pay severance. Now, here's why you want to consider that. Because if your wife accepts this and continues working, by accepting this, she's given them the right to do it again and again. And next year, if they reduce it by another 20%, and the year after, they reduced it by 75%, she won't be able to do anything because she let this reduction happen now. So very important to remember that if you don't stand up for your rights in this situation, you may lose those rights. So she needs to consider constructive dismissal. She should not do anything until she calls me. Okay, she can connect with me through employmentlawyer.ca. She and her colleagues have that right. Okay, there's potentially the ability to delay having to make this decision. I said the decision is to either accept or consider a constructive dismissal. The decision has to be made now unless you do something to delay it, and we can talk about that. So have your wife contact me as soon as possible. Again, employmentlawyer.ca. Maddie has the next question, a follow-up on my question about unpaid overtime. Can I speak on behalf of other employees? I am quitting my job there, but I don't like how my colleagues are not getting paid for overtime. No, unfortunately, you cannot. They have to deal with it themselves, Maddie. Let's see. Sherry has a question. Sherry says, can you tell me how severance would be calculated for a misclassified independent contractor? My monthly invoices vary. Some months I bill up to $5,000, where others I may bill $2,000 to $3,000 depending on work. Very easy. Okay. First of all, many individuals are misclassified. They call themselves, or the company they work for calls them independent contractors, but they're really employees. If you look like an employee and you act like an employee, you are an employee. So I'll give you an example. So if you have a problem with your sink or your toilet, you call the plumber. The plumber comes in, he fixes the problem, and he bills you. You pay them, and that plumber then moves on to another customer. That's an independent contractor. Even though the independent contractor came to you and worked for you, and you paid them, they're not your employee, right? That plumber is in business for himself. He has his own plumbing business, and he provides services to various customers. Well, that's what an independent contractor is. On the other hand, if you go to work for the same company, they tell you what to do, you go there kind of every day, you've been doing this for a while, you're not like the plumber. You're an employee. And it doesn't matter if you call yourself an independent contractor. And if you lose your job, you're owed severance because you're an employee. So to Sherry's question, in terms of how do we calculate severance, we simply look at an average. So depending on how long you've been there, we look at 1 or 2 or 3 year average. So if on average you bill $3,500 a month, so that's your monthly salary, that's the figure we're going to use to calculate your severance. So it's simply an average. Very, very simple. So if you lose your job, Sherry, if you've been misclassified, or if you're not sure, just call me. Okay, connect with me through employmentlawyer.ca. And by the way, I mentioned pocketemploymentlawyer.ca. In that website, on that website, we have a tool that allows you to determine if you're actually an employee or an independent contractor. So if you're not sure, just go to pocketemploymentlawyer.ca, hit or click on our independent contractor tool, use it, and you can find out. Thank you for that question, Sherry. For those joining us for the last few minutes of this session, welcome. I'm Lior Samfiru, the employment lawyer. I'm here answering questions about employment law. I've been getting lots of questions today. I'm going to continue answering them. You may have an opportunity to still get a question in under the wire, so ask your question right now. All right. Next question. I don't know how to pronounce the name, from Ciporqueno. Sorry if I mispronounced. Your videos and lives are the best. She said that a friend of mine tried 2 times to call your office, but they had a hard time due to availability of lawyers. Can you address this? So listen, we are the biggest and the busiest employment law firm in this country. Okay. Some weeks we have a lot of availability, other weeks we don't. I'll tell you this, we're worth the wait. Okay. There's a reason we're the biggest, we're the best, we're the busiest. That's all I can tell you. It's worth the wait. Too many times we get contacted by people that spoke with other lawyers that didn't work out, and they're coming to us to fix the problem. Don't let that happen to you. All right. So Sherry had a follow-up. Recently, my work has dwindled, and I've only been able to bill $1,000 a month. The company also reduced my purchase order amount for the year. Would now be time to negotiate an exit? Well, it's not about negotiating an exit. It's about the fact that this may be a constructive dismissal. So you may be able to force them to pay you severance. So let's chat about it, Sherry. Connect with me through employmentlawyer.ca. Let's see. Della has a question. Della is also joining us on YouTube. I was just given working notice with a termination date in July. I have not yet received my severance package. Do I need to work this as it states? If I don't, they will not give severance. Yes, you do. If you leave before your last day, you may be considered to have resigned. And if you resign, you don't get anything, right? So that working notice, so between now and July, whatever that 2 or 3 months that between now and July counts towards your severance, but you're still owed severance on the back end of it. If you want to know how much severance, I mentioned, you just go right now to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. Use our severance calculator, and you can find out how much severance you are owed. When they offer you your severance, I can almost guarantee you that you're going to be owed more. So when that happens, when you have that piece of paper, call my office, okay? Let's make sure you get everything that you're owed. And please, 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 do not sign anything until we've spoken. All right, Della? Again, to connect with me and my team, employmentlawyer.ca. Let's see. Okay. Bilmal who had a question about his sister. I think it was a sister or a friend. She's a temporary resident. Are her rights the same as permanent resident? Does a lawsuit against an employer create an immigration problem? She has the same rights. It doesn't create a problem at all. But here's the thing. You say lawsuit. Our job is to resolve it without even having to do that, okay? And in the majority of cases, we're able to. If we know what we're doing, and we do, we can resolve it even without a lawsuit. It's not a big deal if we have to go that route, and sometimes we do, but that's not our goal. Our goal is to find a way to resolve it without it. And yes, she has the exact same rights as everyone else. As long as she's working legally in Canada, she has the same rights as every employee, okay? So have her contact me through employmentlawyer.ca. All right, a couple more questions here, guys. Next question comes from Ralph. How long do severance negotiations typically last? 26 years at a company, laid off without cause. So, very good question. In the majority of cases, they take a few weeks, 3 weeks or so to resolve. The majority of cases. And probably 90+% will resolve within 3 months. So most within 3 weeks, the 90+% within 3 months. Now, you were there for 26 years. Now, I don't know what job you were doing. I also don't know your age, but someone after 26 years, you could likely, very likely, owed as much as 24 months of severance. And the nice thing about someone that's been there as long as you, these things tend to be more simple to resolve. The company is not going to be able to say, oh, you're only owed 7 months after 26 years. It's ridiculous. So don't be afraid of the process. Usually it's a straightforward process. Usually we can resolve it quickly and on excellent terms. So the next step, Ralph, do this today. Don't wait, okay? Connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. That's the way to connect with me and my team. Let's sit down. Let's go over everything. Let's make sure you get what you are owed. All right. Let's see, guys, I'm Lior Samfiru, employment lawyer. Let's see if I can get to Della's question. Is it possible to recoup any time period worked as part of a working notice, or is it just deducted from your severance? So it counts towards your severance. So as an example, let's say you're owed 10 months severance, but you got 3 months notice. You got 3 months working notice. That means that the company owes you 10 months minus 3 months. So they owe you another 7 months in that example. Okay, so that's how it works. If you were provided working notice in writing with a specific end date, well, that notice, that amount of notice that you got counts towards your severance. Okay, so it's as simple as that. On the other hand, if the notice was not an exact, for example, they said, well, your job is going to end at some point in the next few months. That's not going to count. That's not going to reduce your severance. But if it said your job ends on July 2nd, well, then that is a specific amount of notice, and that does count. Guys, I think that is the time that we've had for today, and I think I'm caught up on the questions. I'm glad I had a lot of questions to answer. I will be back here next week. Of course I will be, but please don't wait until then. I've given you my contact information. You can do that again through employmentlawyer.ca. Connect with me now. Okay, don't sit on your rights. Remember what I said earlier, that sometimes if you sit on your rights and don't enforce them, you lose them. Don't let that happen to you. Please don't. Let's make sure we enforce your rights. Whether you have a follow-up question you want to discuss, whether you actually want help to resolve those issues, to get you severance, to get you what you're owed from your employer, very easy to do. Go to employmentlawyer.ca. We'll make it happen. Thank you guys so much for joining me today. Always a pleasure, always a privilege. I'll be back next week. We'll talk to you all again soon. Take care of yourselves. Bye-bye.